Hi, I'm Fiona Henderson. This week I've taken a few days off work to come down to our farm in rural Victoria to shear our sheep in preparation for the hot summer. This week I'm going to talk about how to prepare a foreign witness for cross-examination. Of course, much of this applies to any witness, but there are some specific things that I do with foreign witnesses to help them feel more comfortable with the Australian process. The first and best preparation for a witness is to invest the time to get the detail of their affidavit correct. It makes such a difference to a witness when their first affidavit has carefully dealt with all relevant matters and documents. In particular, it really needs to deal with any controversial matters that the witness is likely to be cross-examined on. This is because an affidavit is the best chance and usually the only chance a witness will get to give their version of events or their explanation of a matter in their own words. Cross-examination is not the place to do that. Neither is evidence in reply nor re-examination. The second thing when dealing with a foreign witness whose first language is not English, you need to decide what language their evidence should be in. It is important to remember that preparing an affidavit in English, whilst a lot easier than doing it in a foreign language, is a very different matter from being cross-examined in English. If a witness is not going to cope with a cross-examination in English, then a decision needs to be made from the outset to give their evidence in their native language. Getting the best outcome from translators as interpreters is a whole separate topic to be saved for another day. Safe to say, the language in which a foreign witness gives evidence is a forensic decision that should be given careful consideration at the outset, as it will have significant implications for their cross-examination down the track. The third thing I do with a foreign witness, with all my witnesses actually, I spend time with each of them before they give evidence to explain the best way to answer questions under cross-examination. There is an art to answering questions in cross-examination. It is not to hide the truth, but there is an art to giving answers in a way that will minimise the impact of the cross-examination. I have 10 golden rules. Most witnesses find this really beneficial, especially when you allow the extra time needed to help them understand why these guidelines will help them in cross-examination. The fourth thing I do is spend time with my witnesses going through the general topic areas they can expect will be covered in cross-examination. Sometimes we do this 3 or 4 times, and we do it throughout the course of preparing their affidavit as well as shortly before giving evidence. This is particularly important where the witness is giving controversial evidence on an important fact. I make sure they have the opportunity to ask all of the questions they have about their evidence and the process so that they feel comfortable about what will happen and what they can expect. Doing this 1 hour before their cross-examination is not the time. Because a witness is not allowed to sit in court during the hearing until they have given evidence, I take every foreign witness who comes to Australia to give evidence in one of my cases to court to watch a hearing in action. This is so they know where to sit, how to address the judge, who the people are in the courtroom, what to do when they're asked to swear an oath or make an affirmation. It makes the whole process less daunting and gives them the benefit of some familiarity with our system to lessen the power imbalance at least a little. I try to find a case where there is a witness being cross-examined, and we go together and sit and watch the cross-examination after I have spent time with them explaining to them the guidelines for giving evidence, so that they can then see it in action. We then spend some time discussing what happened afterwards. I always hope that I'll find a really terrible witness who is breaking all the rules so that they can see why the rules work so well. It doesn't always happen. Once I've done all these things, I send them away. to read and reread and reread again their affidavit and the documents that are attached to it, so that they're completely familiar with it and comfortable with their evidence. I'm often surprised by how little time is spent preparing witnesses for cross-examination and how often it is left until the hour before they are about to enter the witness box. It's actually very unfair on a witness to do that. They need time to absorb and to process and to think about it, and the time to do that is not an hour before they give evidence. It only adds to their nerves. The value that a well-prepared witness can bring to a case makes it worth investing that time in the days leading up to the hearing, so that your witness has time to process and digest everything and come back to you with any questions. Until next time.